chairperson of the EC to be cross-examined, but the councils did indeed indicate that they were not willing to. Following that decision by the councils, the lead counsel for the petitioner then applied to the court to be allowed to reopen his case in order to be able to subpoena the EC chairperson to be cross-examined. You will also recall that the refusal, so to speak, of the respondents, the first respondent in particular, to make available a witness is what led to the decision by the lead counsel for the petitioner to apply to the court to reopen his case. After several arguments and debates in court, making references to legal precedents and other matters related to law in court, from all sides, talking about the petitioner making his case and the first and second respondents also making their case, the court ruled that it would not permit the petitioner to reopen his case. And that's what has brought us here today, because on Friday we cited documents that had been submitted to the court by lawyers of the petitioner, indicating that they wanted the court to review its own decision, the decision it took. This would be the third time the petitioner is asking for a review of a decision by the court. Indeed, we know the two previous occasions the petitioner asked for a review, both reviews were dismissed. The panel of 7 was changed to a panel of 9 on those two occasions, and the unanimous decision had always been the fact that the petitioner's request for review did not have solid grounds. Mr. Frank Davis is a member of the legal team of the the second respondent, in this case, Nana Adodanka Kufado. He has also just come in, and when the persons who are central to the case begin to make their appearance in the court premises and walk into the courtroom, that always gives an indication that sitting is just about to begin. And so in the last fortnight, the controversy has been around, indeed, whether or not Madame Jane Mensah should be cross-examined. The petitioner insists that Madame Jane Mensah should be cross-examined. This is because, according to the lead counsel for the petitioner, during the cross-examination of the 3 witnesses of the petitioner, Mr. Johnson Esedun Ketia, Dr. Michael Kwesa-White, and Mr. Robert Joseph Metal Nunu, that some allegations did come up, and those allegations can only be answered by the chairperson of the EC. But the court has ruled that a party cannot be compelled to give witness if that party so wishes not to do so, and that has been the controversy, and the court arrived at a decision. The decision is what the petitioner is asking the court to review today. Meanwhile, the court had earlier on asked, of course, okay, so the court is just about to start. So Nana B is one of the spokesperson of the legal team of the respondent here, has also just come in. So we'll go to the courtroom right now and bring you more details later on.
Respectfully, my lords, writ number G1/5/2021, John Dramani Mahama versus Electoral Commission of Ghana, Nana Adodanka Akufo-Addo. Please, who is representing the petitioner? Please. My Lords, Nana Opoku Ajuma is representing the petitioner. Electoral Commission of Ghana, my Lords, Jane Mensah, chairperson, representing the first respondent. Peter McMahon, my Lords, is representing the second respondent.
It please my Lord, to Melissa for petitioner applicant. My Lord, I'll be led by Mr. Shikata. Please just step up with me. Should be here in a moment.
Yes. May it please the court, Justin Amenuvo appears for the first respondent with Alexander Tomasamoa.
If it pleases your lordships, I put on call for the second respondent. My lords, with me are my learned friends, Frank Davis, Kweku Sifi, and Yao Pong.
Yes.
My Lord, there are two applications scheduled for this morning. One is the stay of proceedings. In view of the fact that both are scheduled for today, and the review will be taken today, I crave your indulgence to withdraw the application for stay of proceedings. Oh, yeah.
The extension of time. It should also be before the ordinary bench. So that was why we decided that we can take. The lead counsel is now in. Yes.
Very well.
You can take the review.
So Mr. Chikata will take the review.
My lords, respectfully, we have an application for review before your lordships.
Time management, you have 30 minutes.
Very well.
And there will be no extension of time.
I'm sorry, I didn't hear that.
There will be no extension of time.
The application for review is brought under Article 133(1) of the Constitution and Rule 56 of the Supreme Court rules. I respectfully move in terms of the motion paper and the supporting affidavit. And this review is in respect of our application to reopen our case. And your lordship's ruling is
first exhibit attached to the application. And in our respectful submission, as our ground A indicates, this ruling was per incuriam section 72 of the Evidence Act 1975 and has occasioned a grave miscarriage of justice. There's no question that in your Lordship's ruling there is no reference whatsoever to section 72 of the Evidence Act. Instead, there's a reference to Black's Law Dictionary, which is an English law text. No reference is made to section 72 of the Evidence Act. Section 72 of the Evidence Act is a statute of Ghana. No reference is made to that, and instead there is a reference made to an English law textbook, which is not what is binding on your Lordships. That is why we say respectfully that that decision was per incuriam section 72 of the Evidence Act. And my lords, the authorities are clear, and we have cited Republic against Tete, which is 2003-2004, Supreme Court of Ghana Law Report 140, where their lordships in the Supreme Court reversed a unanimous decision that they themselves had given, and they reversed that decision on the basis that they had failed to take into account the Armed Forces regulations, which were part of what their duty was as a court of Ghana. They had failed to take it account. They had failed to take it into account. And so their lordships in Republic against Tete reversed a unanimous decision that they had taken, and they unanimously corrected an error. Now, my lords, in another ruling your lordships have given in this case recently, your lordships have said that even if you did not refer to a certain statute in your judgment, we have not shown that it occasioned a miscarriage of justice. My lords, respectfully, that is fundamental error. Republic and Tete shows that once there is no reference to a statute which is binding on your lordships, we do not need to show further that there is a miscarriage of justice. The failure to apply a statute of the law of Ghana is enough of a miscarriage of justice in accordance with the decision Republic and Tete. And if non-compliance with a statute of Ghana, if that is not a miscarriage of justice, respectfully, I do not know what is a miscarriage of justice. Section 72 is very simple in its terms. Section 72, subject to the discretion of the court in a civil action, a party or a person whose relationship to a party makes its interest substantially the same as a party may be called by any adverse party and examined as if on cross-examination at any time during the presentation of evidence by the party calling the witness. Yet, this is what your lordships say in your ruling. At page 5, your lordships say, the question is, how can the chairperson or the first respondent vindicate herself when she is not on trial before us? She has neither been personally sued nor arraigned before this court on any complaint or accusation for which she has to explain or account to anybody. It is the institution, the Electoral Commission she heads, that has been accused by the petitioner of not having performed his role. Now, my lords, I mean, respectfully, that is not even true. We have respectfully brought the attention of this court, her failure, her singular failure to perform her roles. We do not simply come before this court talking about the first respondent as a commissioner. We specifically have raised issues. The heart of this case is about her declaration. But these are the questions. And then your lordships go on. What indeed baffles this court is the intimation by counsel for the petitioner that he intends to call the chairperson of first respondent as an adverse witness. Black's Law Dictionary defined a hostile witness as so-and-so. There's a whole quotation from Black's Law Dictionary. Then it carries on, in effect, to say that it is only when a witness is in the box that he can be declared a hostile witness. My lord, that is not the law of Ghana. The law of Ghana is not what Black's Law Dictionary is saying, or what their lordships based on Black Law Dictionary are saying. The law of Ghana is what I read from section 72. That says a party may be called. A party may be called. It's not that when they are in the witness box, then they can be turned into a hostile witness. That is not what the statute law of Ghana says. And my lords, it is fundamental and egregious error when on the basis of Black's Law Dictionary, we have the courts of Ghana going against a statute of the land. Ground B of our application, of our grounds. Ground B says that the ruling was in fundamental error in subjecting statutory provisions in the Evidence Act to the provisions of subsidiary legislation. My lords, there again, nothing could be more basic. Nothing could be more basic than the fact that a statute is superior to subsidiary legislation. The Rules of Court Committee are not of a higher standing than the Parliament of Ghana. And so when you have a judicial decision of the highest court of the land effectively subjecting Parliament's law to the Rules of Court Committee, that is fundamental.
Mr. Chikata.
Yes.
Are you suggesting that CIs do not go to Parliament?
CIs go to Parliament. They go to Parliament in a different way from how statutes go to Parliament. That is why the Constitution makes a distinction between the exercise of powers by people such as the Electoral Commission, who take the CIs to Parliament, and if there's no objection, it goes through. That is a different process from a statute, which is an act of Parliament which overrides subsidiary legislation. My lords, there can't be any question. And if your lordships have an issue with that, I'm afraid that that is just fundamental error. There can't be any question that subsidiary legislation, such as is contained in a constitutional instrument that brings into effect what the rules of court have done, there can't be any question that those are subordinate to the Evidence Act. There can't be any question about that. So where in your ruling your lordship say that you're not going to apply the Evidence Act because there is a rule of court, and that rule...
Isn't that the exercise of our discretion which prefaces the section that you read?
My lord, those are not the terms of the ruling. The terms of the ruling that your lordships gave, the terms of your ruling are very clear. And unless the ruling is being rewritten, the terms are very clear. Namely that the evidence section 20, we wish to state that, this is at page 10 of the ruling, we wish to state emphatically that section 26 of the Evidence Act, which is on conclusive presumption, is not applicable in this case in view of Order 38 Rule 3E5. That is what the ruling says. It doesn't say that in the exercise of my discretion, this and that. It doesn't say that. It just says it is not applicable. That is what it says. Nothing more nothing less.
Mr. Chikata?
Yes.
Do you have a list of everything that the panel took into account before coming to that conclusion?
It is a ruling of the panel that we are here to question. And the ruling in its terms is what is before us. Obviously, I'm not in the minds of the panel, and I'm not able to divine whatever went on in their minds, except by reference to the terms of the ruling. And my lords, in any event, Order 38, Rule 3E5 has nothing whatsoever to do with application of the Evidence Act, Section 26. Order 38, 3E5, it reads as follows, that is as amended by CR 87. If a party who has served a witness statement does not call the witness to give evidence at the trial or put the witness statement in as hearsay evidence, any other party may put the witness statement in as hearsay evidence. That provision has nothing to do with the Section 26, which the court was stating emphatically is not applicable because of this order. The terms of this order are themselves very clear. They do not have anything to do with what Section 26 says. What Section 26 says is, again, not controversial. What Section 26 of the Evidence Act says is simply establishing a conclusive presumption in a circumstance where somebody has put before the court clear indications by way of affidavits that she will be available to be cross-examined. That leads to what Section 26 describes as a conclusive presumption based on the estoppel by own statement in Section 26, except as otherwise provided by law, including a rule of equity. When a party has by his own statement, act, or omission intentionally and deliberately caused or permitted another person to believe a thing to be true and to act upon such belief, the truth of that thing shall be conclusively presumed against that party or his successors in interest in any proceedings between that party or his successors in interest, and such relying person or his successors in interest. Order 38, 3E5 has no relevance in terms of that. And our submission is simply that the court cannot sideline the operation of a statute by reference to subsidiary legislation, which in any case has no relevance to the issue of Section 26. My lords, we indicate in ground C, in ground D, so we've dealt with A, B, and C. We indicate in ground D, we take B and C together. And I argue in relation to B and C that the fundamental errors consist of sidelining legislation in favor of subsidiary legislation, and in relation to ground C, sidelining it in favor of subsidiary legislation which is irrelevant to the issue in the statute anyway. And so we move to ground D. And in ground D, our submission is that here again, the court made no reference whatsoever to Order 38, Rule 10 of CI 47, nor indeed Section 58 of the Courts Act. And Section 58 of the Courts Act is a section which even gives power to your lordships to call a witness. And that section has been properly applied. So in other words, apart from our ability to subpoena upon reopening of our case, apart from that, there is also the opportunity for this court itself to call a witness. And the circumstances in which the court does that, those circumstances are exemplified in the case of Wardier and Bukhari. Wardier and Bukhari, 1976, 2 Ghana Law Reports, 371, where the Court of Appeal, the then Apex Court, proceeded as follows. And this is from the judgment of Justice of Appeal Archer, as he then was. After judgment had been reserved in this court, it was felt that this court should not be placed in the same situation in which the court below found itself. It was therefore decided to ascertain the truth in this matter, and so on. And based on that, the court had recourse to the Courts Act to ascertain the truth of the matter. And then the court went on to point out that just that invitation of the witness to come and testify had brought up a very important piece of evidence, which, if it had been adduced in the court below, would have spared that court the torment of exploring whether or not the certified true copy of the plan from the Lands Department was the plan tendered before Jackson J. And the court even goes on to say one can understand Mr. Joe Rindolph's initial reservations, but as this additional evidence has enabled this court to ascertain the truth beyond all doubt, we think by allowing this additional evidence to be admitted, Mr. Rindolph conducted himself in the best traditions of the bar. Indeed, those words in respect of the best traditions of the bar evoke some nostalgia in the hearts of some of us. And my lords, we are respectfully saying that the ruling that your lordships gave did not even advert to Order 38, Rule 10, which we had indicated was the basis on which we were seeking to reopen our case. It didn't even advert to that, and it was therefore per incuriam. We say also in ground E, which I move on to now, that the ruling was per incuriam Article 1913 of the Constitution and has occasioned a grave miscarriage of justice. And Article 1913 is the provisions on the right to a fair trial in this court. And we show in our submissions on that matter how this Supreme Court adverted its mind to a decision of the Supreme Court of the Netherlands, in which the Supreme Court of the Netherlands was highlighting the importance of ascertaining the truth in matters that were before it. And that was made to displace, in the interest of the right to a fair trial, it was made to displace even international relationships as being something that the court would have reference to. That decision in the case of Chachuchikata and the Republic is a decision that we have cited in our submissions, and I will not go further into that, except to underline the fact that the Supreme Court of the Netherlands, whose reasoning was adopted by the Supreme Court of Ghana, also considered it appropriate that in the interest of ascertaining the truth, it was of value to the court to call a witness.
Once again, I'm curious about something. If it was so important to you to have a particular person testify for you, why do you not present that as part of your pre-trial positions?
My lords, we could not, for the reason that I've given a few times in this court. At the time, that first respondent's chairperson was the person who had filed a witness statement on behalf of, well, first of all, had filed an affidavit of verification of the case of the first respondent. Subsequently filed a witness statement on behalf of the first respondent. And my lords,
so in essence, you were hoping to rely on her coming to testify and found yourself without that. And that is why now you are asking that she comes as your witness after everyone has closed their case.
My lords,
is that what you're saying in essence?
My lords, what we're asking is for our case, for us to have leave to reopen our case. That witness, as we've indicated, had sworn affidavits in response to our application for interrogatories, in response to our application for stay in relation to that. And in those, she had given every indication that she would testify. We had no reason to believe that she wasn't telling the truth. We had no reason to believe that she didn't mean it when she swore those affidavits. We had no reason to believe that anybody in the court would have assumed other than that she would testify. In fact, the day that it was announced that she would not testify, on that day, your lordship themselves expressed, some surprise, and that was the reason why you adjourned to the next day for arguments to be raised and so on. So, my lords,
Mr. Chikata, when you announced that you had closed your case, what did you mean?
Nothing more, nothing less. We had closed our case. And when we announced that we are seeking to reopen our case, I mean exactly that, nothing more, nothing less. We are seeking leave to reopen our case in circumstances where a person who has deposed to affidavit saying she will be available for cross-examination, and where your ladyship specifically had intimated that the questions that we're seeking to raise in interrogatories could be asked of her in cross-examination. I'm sure your ladyship has not forgotten that bridge. And in that context, your ladyship had said that aren't we crossing a bridge that we have not got to? And we indicated that at the stage of interrogatories, we still found it appropriate to anticipate that. But your ladyship said the bridge will be there. That bridge is no longer there.
When you said that you had closed your case and you meant it, nothing more, nothing less, what did you mean?
I really don't understand what more your ladyship wants by way of an answer. We meant that we had closed our case. And we had closed our case, and subsequently we sought leave to reopen our case. Your ladyship cannot say that we are not able, under the rules, under your inherent jurisdiction, to ask for your leave to reopen your case. I don't believe that that is a suggestion that your ladyship is making.
I don't think I've said any such thing.
So but it's very difficult to comprehend.
I just wanted to understand what you meant when you said you have
I've answered that question, I think, twice or thrice already.
Nothing more, nothing less. And I'm satisfied with the answer, sir.
My lords, we continue finally to the last ground, that the ruling was in breach of Article 296. And my lord, very simply put, what we're saying is that that ruling is completely unreasonable in terms of what are often referred to as the Wednesbury principles. And her ladyship, Justice Georgina Wood, as she then was. In the case of TDC and Musa against Atab Balfour, 2005-2006 Supreme Court Law Reports, page 121. Your Ladyship's, her Ladyship, at page 131, expressed the specific terms of what such unreasonableness amounted to. And by saying that he, that is the plaintiff in this case, succeeded in showing that the case fell within the irrationality or unreasonable rule, in that the decision arrived at by the TDC defies logic and common sense or accepted moral standards, and that without meaning any disrespect to the TDC, no sensible or reasonable person called upon to apply his or her mind to the decision to be taken could have come to that decision. In short, the decision to throw him out of the house and foist a residential plot on him is irrational and unreasonable. And we are saying respectfully that your lordships, in the exercise of your discretionary powers, unfortunately failed to advert your minds to relevant statutes, introduced irrelevant considerations which prejudiced a fair exercise of discretion as required by Article 296 of the Constitution. It is our submission that holding the first respondent, and particularly his chairperson, accountable for the exercise of powers conferred by the Constitution and statute justify, in the circumstances of this case, that that chairperson be called upon to testify using the time-tested subpoena procedure that we seek to invoke in this case. My lords, there is no question that the process of review is among the ways in which corrections are made by your lordships. And as Aqua...
Your time is up.
May I just finish in a minute, because I'm in the middle of a sentence. Is that allowed?
Okay. You may finish.
As Aqua indicated in the Koblex case, heeding the promptings of conscience, as he put it, heeding fidelity to the judicial oath, he found it appropriate to reverse a decision of the ordinary bench. May each of your lordships decide in accordance with your conscience and your judicial oath. Ultimately, and even more profoundly, it is for the chairperson of the first respondent to come forward to testify as she indicated on oath she would do. I conclude with prophetic words that were spoken centuries ago. For they sow the wind, and they shall reap the whirlwind. These are the words of the prophet Hosea, to be found in Hosea chapter 8, verse 7. He that has an ear, let him hear.
Order in court, please. Order.
Yes. My lords, we are vehemently opposed to this application for review number 3. Lord, we have filed an affidavit in opposition as well as a statement of case, and we rely on it. Lords, under Article 33(1) of the Constitution,
this court may review 133.1, my lords, 133.1 of the Constitution. This court may review any decision made or given by it on such grounds and subject to such conditions as may be prescribed by the rules of court. Also, even the Constitution recognizes the role that is played by the Rules of Court Committee. And indeed, my lords, the Rules of Court Committee passed the Supreme Court Rules 1996 CI 16. And lords, the specific rule on review is Rule 54. Lords, this court is the final court of the land. We concede that the court is not infallible. But, my lord, your lordships may change your mind in an application for review only when certain conditionalities have been met. Lords, those conditionalities have been set out in Arta number 2 versus Arta number 2 to 2013-2014, 1 Supreme Court of Ghana Law Report 569 at pages 579 to 580. Lords, I will not read those conditionalities, but they are there. Lord, it's only when those conditionalities have been met that the review panel should seriously consider the merits of the application. Lord's submission that the conditionalities set in Rule 54 of CI 16 and ATA have not been met by the applicant in this application. Lords, with the greatest respect, the grounds are basically an academic treatise of alleged erroneous pronouncements made by your lordship panel of 7. Indeed, if we want to give some credit to the grounds, my lords, they are at best additional grounds that have been filed without leave of your court in terms of an appeal, but they do not form grounds for review for which my lords should grant this application. My lords, may I refer your lordships to the ruling that has generated this review at pages 11. With your kind permission, your lordships held, accordingly, in weighing the propriety of reopening proceedings to permit new or additional evidence to be led or tendered, the court will typically consider the following broad questions. 1, will the evidence, if it had been presented during the trial, have had any influence on the result? 2, could the evidence have been obtained before or during trial by the exercise of due diligence? Then your lordship conclude that thus, in this application, the petitioner has not given us an inkling of the new or fresh evidence he wants to bring to the fore. Neither has he disclosed how that evidence would advance the cause of his petition. Lord, I believe that this is the crux, this is the ruling that the court made. And in the absence of any attack or any submissions regarding this application must fail. Lord, I submit further that the grounds are very misconceived and have no bearing at all on your ratio that I've set out above. Even as submissions were made by the counsel for the applicant, And even as I'm speaking, still, my lords, the court is still not aware. It still doesn't have the inkling of the evidence that the applicant wants to lead for which the case should be reopened. And Lord, this leads me to the Wardier case that was cited by counsel for the applicant. Because in that case, the evidence was known. The evidence was that there was an issue about Exhibit A. And by agreement of counsel, the court then said that let an expert come and testify as to the authenticity of the document. So in that case, the court allowed further evidence just because the evidence that the expert was being called was known. This is not the situation in this case. Lord, what has been done is that there has been arguments that border on the nature of an appeal. Indeed, if my lords look at paragraph 3 of the affidavit in support, with your kind permission, if I may read, he says that at the hearing of this application, I shall, through my counsel, seek leave of this honorable court to refer to all processes filed in this case up to the date of the hearing of this application, clearly indicating to your lordships that he is going to argue an appeal. And that is why your lordships...
It is an application based on previous process.
Yes.
You see, so in motions,
yes,
what you try to do is that instead of seeking leave when you are on your feet, yeah, to refer to it,
yes,
you can capture it in the affidavit. Yes. So yes, don't ask for this one.
No, my lord, if my lord could hear me on the point I seek to make is that as a result of that, the submissions that were, for example, dealt with on the 18th have been brought in. For example, section 26 of the Evidence Act was dealt with. That's the point I seek to make by referring to this submission. My lords, this court has said time without number that the review jurisdiction is not an opportunity given to a party to come and argue the case again as if the review panel is sitting in judgment on appeal over the ordinary panel. And this is what my learned friend has sought to do. Lords, may I crave your indulgence to refer to the Standard Bank Offshore Trust Company Limited versus National Investment Bank. Lords, in civil motion number J7/15/2017. Lords, Doche JSC, delivering the ruling of the court, admonished sore losers at page 17 of the judgment thus. From the ratio, with your kind permission, from the ratio of the decided cases of this court on review, it is immaterial if the applicant for a review considers the decision of the ordinary court to be wrong in law or has an emotional reaction to it, as in this case, the magnitude of the amounts involved or the shutting of the door to applicants because of the effluxion of time in instituting a fresh action. These are not factors that a review bench normally takes into consideration, my lords. Lords, in that case too, the court went on and held that the rules of the court forms an integral part of the laws of Ghana, and consequently, they must be given an equal amount of respect in order to produce the sanctity in court proceedings.
Mr. Menuvel,
yes, sir.
Are you referring to me as a sore loser? I argued that application for review before this court. I was standing where you were some few years ago, yeah, and I lost that application.
Well, Well, my lords, the review panel forms that view of you. The review panel forms that view of you, my lord, and indeed of your client, my lords. My lords, incidentally, my learned friend was on the other side in that matter, and he got the review. Yes. My lords, the case of Mechanical Lloyd Limited versus Nati again is there on the point. Lord's arguments have been made in this court regarding fair trial. My lords, I ask just a couple of questions of the petitioner. This petition, my lords, has been conducted in a piecemeal fashion, which is one of the things that CI 99 deprecates. First, orders of the court are disobeyed, file, witness statement no. You yourself intimate that I am going to call 5 witnesses. You call 2. And then you come back to the court, oh, my lord, I forgot one person, permit me. It is permitted. You call that person. Yes, my lord. Oh, my lords, this is the issue of fair trial. My lords, with the greatest respect, the issue of fair trial has been raised. And now I'm saying that he has been given fair trial in the way the case has been conducted, my lord. Lord, then we go from there to having called the 3rd witness. What is your pleasure? Oh, my lords, I close my case of your own volition. Lord, it is my submission, therefore, that the petitioner was given every opportunity. He was fairly heard in these proceedings. And what has been filed, review number 3, is an abuse of the court processes, and the application ought to be dismissed in limine.
Mr. Menuva, you have not addressed us on the reference to Hosea, the gospel according to Hosea. Yeah.
My lords, I made
order, please.
My lords, my point I wish to make on that, if you permit me, is that God is a God of conscience, and God does not use court processes to elicit conscience. No. God is a cause of conscience, and therefore you do not bring God into the courtroom to now claim that because of God, application should be granted. That's my response.
Isakutampa.
30 minutes.
My lords, we are opposed to this application, and my lords, we rely upon affidavits in opposition filed on the 21st of February, together with our statement of case. My lords, our first submission is that this application woefully fails to satisfy the conditions for the grant of a review application. As in our view, it does not demonstrate any fundamental error committed by the court which has occasioned the petitioner a miscarriage of justice. And on that ground alone, this application ought to be dismissed summarily. My lords, now on ground A, of petitioner's application, the petitioner refers to Section 72 of the Evidence Act. Now, my Lord, Section 72 of the Evidence Act reads thus. 72 sub 1. Subject to the discretion of the court, in a civil action, a party or person whose relationship to a party makes its interest substantially the same as a party may be called by any adverse party and examined as if on cross-examination at any time during the presentation of evidence. At any time, my lords, during the presentation of evidence by the party calling the witness. My lord, it is very significant that in his statement of case, there is a deliberate omission of the controlling word evidence by the party of evidence. That is, and I see no reason to believe that this was inadvertent, because it is repeated twice. And on both occasions, this critical word is left out of evidence. Now, what is the significance of adding of evidence, reading Section 72(1), including of evidence? It means that a party can only exercise that right when he has not closed his case. That's what it means. And I want to repeat this. Section 72, which appears to ground the backbone of this application, relates to a situation where a party has not closed its case. Now, in this instant situation, the party had closed its case. So the court had no business referring to Section 72(1) because it was irrelevant to the circumstances of the case. And my lords, it is my submission that knowing that they have closed their case, the petitioner disingenuously omitted of evidence. And with all due respect, this is highly improper. So, my lords, all the submissions around Section 72 that the court was per incuriam of Section 72 are totally unmeritorious and irrelevant. Now, my lords, we proceed to deal with grounds B and C. And my lords, counsel for petitioner has argued that Order 38, Rule 3E, 5 cannot override Section 26 of the Evidence Act, because in his view, the Evidence Act is a substantive legislation, and Order 36 subsidiary. My lords, 38, sorry, is subsidiary. My lords, it may well be the case that Order 38, Rule 3E5 is a subsidiary legislation. But the point here, the critical point here, is that the very principal act, this is the Evidence Act, Section 26, by itself delimits the application of the main text by the words subject to a rule of law or equity. And my lords, there can be absolutely no doubt that Order 38, Rule 35, is part of the laws of Ghana. So it is because of the specific provisions of Section 26 that the court could then look at Order 38, Rule 3E5 and rely upon it in making its ruling. So, my lords, respectfully, I think it is misconceived to suggest that in doing so, the court has committed a fundamental error by allowing a subsidiary legislation to trump a substantive act of Parliament. My lords, we would next address Rule Ground C, which relates to Act 459, Section 58. Ground D. My lords, in my respectful view, Section 58 of Act 459 is completely irrelevant to the matters before the court. Because the matters before this court, which is the subject matter of the review application, relate to the court's decision not to reopen a case. My lords, that is the decision of the court. Now, Section 58 reads, in any proceedings and at any stage of the proceedings, a court, either on its own motion or on the application of any party, may summon any person to attend to give evidence or to produce any other document. My lords, this provision presupposes that the party who is applying to summon another has not closed his case. Now, this is obvious common sense. It is very clear that this provision cannot relate to a situation where a party has closed his case. And my lord, these are the ways in which provisions of the law have been persistently cited out of context. Perhaps to mislead those who do not know the law. So, my lord, it is our respectful submission that a reference to Section 58 of the Evidence Act, of the Courts Act, in this situation is totally misconceived and should never have been made by counsel. My lords, we wish also to make the point here, for the last time, that The chair of the first respondent has never made any undertaking that she would mount the witness box, such that the petitioner could claim that he relied on it to his detriment. My lords, all that the chair of the first respondent did was to repeat what the law is. That is all that he did. The law, and if your lordships go to order 22, rule order 22, all that the chair of the first respondent did was to repeat the position of the law, which is that if you fail to obtain interrogatories in relation to a matter, you may, during cross-examination, elicit the same information. That is all. It was never an undertaking. And it beggars belief that the petitioner and counsel are basing this statement of the law as an affidavit, an admission or a representation that they relied upon to their detriment. My Lord, I therefore wish to submit that a reference to the deposition of the first respondent's chair on this matter can never constitute an estoppel, because she has the right to refuse not to enter the witness box. And the court has ruled definitively on this. This application for review of the decision to reopen cannot be the back door through which that earlier ruling can be considered. The court has ruled on it, and that ruling binds all of us, including counsel for the petitioner. My lords, the fair hearing argument, my lords.
You have 5 minutes more.
Very well. My lord, I thought I had a lot more minutes. Unless your lordship thinks I've made out my case, so.
You have 5. Out of the 30, you have 5 minutes more. Thank you.
My lord, ground E relates to the allegation of breach of his right to fair hearing. My lord, the right to fair hearing is a right that all parties to a suit are entitled to. So, the court has ruled that the respondents have the right to elect not to adduce evidence. That is their right under the law. Therefore, to seek to reopen your case so that you can compel the first respondent through his chair to enter the box is a breach of the first respondent's right to fair hearing also. My lords, it's our considered view that no evidence or analysis has been made by counsel for petitioner that sustains their claim that their right to fair hearing has been breached. Indeed, this court has been more than accommodating to the petitioner. They defied the court's order with impunity not to file witness statements at the time they were ordered to. They have even again defied the court's order to file closing addresses. And perhaps the court may once again accommodate their defiance of the highest court of this land. And then they turn around to talk about fair hearing. In our respectful view, their case should have been struck out when they failed to file their witness statements as ordered by the court. Or it could have been struck out. And as we speak now, since they have defied once more to file their closing address, this case can be settled without their closing address, and it will be fair trial. My Lord, I'm saying it will be fair trial for that to happen. Possibly the court is once again going to accommodate them. So they should be the last people to be mounting the high horse and talking about breach of their right to fair trial. My Lord, our respectful submission is that this allegation of breach of their right to fair trial is an invitation to the court to go on a frolic which has absolutely nothing to do with the issues before this honorable court, as to whether any person, any of the two parties, the petitioner or the second respondent, obtain more than 50% of the valid votes cast in the 2020 elections, presidential elections. My Lord, again, the reference to 296 is, in our view, quite surprising. Yes, my lords, the court was right in the TDC case to hold that the acts complained of were unreasonable and irrational. But my lords, in the instant application before your lordships, the petitioner has failed once again very badly to demonstrate the facts which ground the allegations of unreasonableness or irrationality. Because those facts, my lord, are based on the grounds that he has dealt with earlier on, A, B, C, D, which we have demonstrated to be hollow and of no merit. Accordingly, my lords, we believe that, and we submit that the application is devoid of merit. It is deserving of a summary dismissal, and given the fact that the arguments are only a rehash of earlier arguments and the introduction of irrelevant provisions for the consideration of this court, we pray that in this exceptional situation, this application be dismissed as an abuse of process. It be dismissed as an abuse of process and cause punitive costs.
Your time is up.
Malted. And Lords, we are done.
Who's that?
My Lords, may I, with your leave, make a couple of brief references. My learned friend for the second respondent, I heard him a little while ago say that we are acting in breach of the right of the chairperson of the first respondent as far as testifying is concerned, as far as our indication that we are seeking to subpoena is concerned. And my Lord, as a matter of law, respectfully, it is not for the second respondent to bring up a witness's claim to immunity, whether on the basis of a right to fair hearing or self-incrimination or whatever. It is not for the counsel for the second respondent to bring up a witness's claim to immunity. The witness must themselves, that witness must, his or herself, I should say, his or herself, put forward whatever claims she seeks to make to immunity. And my Lord, I believe that that was the reason for our reference to the case concerning the IFC's immunity and so on. And my Lord, counsel for the second respondent also sought to suggest that I had somehow sought to mislead the court in terms of section 72. Well, that's a very serious insinuation. Well, it's not actually an insinuation. It was a very express statement on his part. And my Lord, I can only say that counsel is obviously not clear about the nature of the application that is before you. Because the nature of the application that is before your lordships is to seek to reopen our case for the presentation of evidence. That's the nature of the application that is before you. So, reading section 72 about the presentation of evidence and making it seem as if what we are doing is somehow foreclosed because we have closed our case just shows that he hasn't understood why we're in court this morning. Because, my lords, we're in court asking your lordships to reopen our case so that we can go according to certain processes. That's what we're in court for. So for him to be saying that we are trying to mislead you by not referring to during the presentation of our case and so on, my lord, that is just a clear failure to appreciate the terms of section 72. And my lord, he completely does not address the point that we make, that section 72 was not even referred to by your lordships, and that your lordships' ruling is per incurium of that section.
Are you done?
Yes, I'm done.
Yes, I have one question for you.
Yes.
Your arguments, you dwell mostly on section 26. Section 26 of the Evidence Act. Can you show me any conflict between section 26 and order 38? Is there any conflict between section 26 and order 38? 38, rule 3, E5. Is there any conflict?
My lords, I was referring to the fact that the ruling implies that there's a conflict, and that in the ruling it says this section is not applicable because of order 38.3e. And my lords will notice that I in fact went on to argue. I argued that rule 38.3e5 in fact has nothing to do with section 26. Your lordship will recall that I argued that. So I was specifically referring to what was in the ruling. The terms of the ruling are clear.
So it was not a matter of the court preferring subsidiary legislation to substantive
that's what the court said. I mean, I read it. The court said.
No, we didn't say so.
We wish to state emphatically that section 26 of the Evidence Act, which is on conclusive presumption, is not applicable in this case in view of order 38
But it doesn't mean that the court was preferring or raising section order 38, raising 38 against above section 26. That is not what we meant.
Well, my lords, I leave that to your lordships, but the language of the ruling is what I'm referring to. But I leave it entirely to your lordships. The language is that it is not applicable in view of something else. So that other thing is being made applicable, whereas section 26 is not being made applicable. I mean, there's no running away from that. If you say this is not applicable in view of this, then it means that what is you say is applicable.
Yeah. No.
You're setting aside.
That is what I'm not. It doesn't make it superior to section 26.
Yeah, but my lords, how can your lordship say that section 26 is not applicable in view of order 38?
That is our view.
Yes, but my lords, and that was the other point I was going to make, respectfully, and I'm glad that it has come up. The reference has been made to your ruling in respect of another application in which you did seek to consider section 26. And there we argued that no reference had been made. It was clear in curiam section 26. In that ruling again, no reference was made to section 26 at all. In your ruling in that case, your lordship said, effectively, yes, we didn't make reference to that section 26, but we haven't been shown that a miscarriage of justice has arisen because we didn't make reference to it. And my respectful submission is that, and I did say so, that is itself fundamental error. And your lordship should take the opportunity to correct that error, because you didn't make reference to section 26, and you sought to justify that by saying that no miscarriage of justice has been shown to you. And my submission was that when you don't apply a statute, there is no reason for miscarriage of justice to be a further ground.
Different from,
I'm sorry.
When you don't make a reference, it's different from not applying.
Well, my lord, if you don't even make a reference, you can't apply. I mean, if you don't even make a reference to it, you can't apply it. I mean, you make a reference to Black's Law Dictionary. Black's Law Dictionary, you make a reference to that. Black's Law Dictionary is not binding on this court. It's stating common law rules which have been changed by statute in this court. But you make reference to Black's Law Dictionary. But you don't make reference to the statute that is binding on you. Well, that is per incuriam. That's
no. That is your opinion.
Well, that is indeed my opinion, and I think it's backed by a plethora of authorities of this court.
The court will rise to consider its ruling.
All rise.
The small size of motorcycles make riders vulnerable. Your head is the most delicate part of your body. Your head is not much harder than a watermelon. In the event of a crash, if your unprotected head hits the street, you could suffer head injuries. Crash helmets are designed to guard against severe head injuries in the event of a crash involving a rider. As a rider, before you set off, wear protective clothing and a high visibility vest so you can be seen during the day and night. Make sure you wear a crash helmet to protect your head and ensure your motorcycle is in good condition. Ride safe. Stop road crashes now. Stay alive.
This road safety education is brought to you by the National Road Safety Authority.
In Ghana, the environmental speed limit of 30 kilometers per hour should be observed in residential, educational and commercial areas because human activity is dominant. 50 kilometers per hour is for built-up areas and communities along the highway. 90 kilometers per hour is for the highway. The Accra-Tema motorway has a speed limit of 100 kilometers per hour. Where there are no speed limit signs, the national and environmental speed limits apply. So, if you are driving near a school with no speed limit sign, your speed should be below 30 kilometers per hour so you can stop your vehicle if you need to. Stop road crashes now. Stay alive.
This road safety education is brought to you by the National Road Safety Authority.
When you need a stroll out to cry.
consumers and various service providers the opportunity to network and make sales. This February, over 500 local and international exhibitors, factories featuring companies under 1D1F, Rural Enterprises Program, Ghana Export Promotion Authority and more, all on one virtual platform from the 27th of February to the 28th of March. Get access to a virtual networking lounge, allocation of a virtual booth, and enjoy a unique virtual experience. Visit our website on www.straightfairgh.com to register or call 446-9451 or 050-001-5587. Don't miss out.
This advertisement has been vetted and approved by the FDA.
A good papa. Ganabam, if your waist, all your body, you make basa.
Thank you so much. I feel good.
What are you? Ganabam. To wait here for doctor no. Where are you? What was I there? 20 cedis. Mr. Tobacco. Ganabam. Young Tom to her. First at Tobacco. After 20 cedis. Hey.
Nemo, say the Ganabam come. Sound true. So if we have Ganabam, you can resist.
Arguing that apart from the concern that they may be affected, this principle of predictability of the law, there may also be the concern that the court is relying too much on an authority that it is not bound by, in which case that authority should only be persuasive. The court should be persuaded, guided, informed by a particular decision that was not taken within the jurisdiction to take a decision. And in a lot of these cases, or such cases, the court relies on that when there is no authority, or shall I say sufficient authority within the jurisdiction to hold on the particular matter. And so the whole idea of, or the whole point he sought to make with the Black's Law Dictionary versus statute is this, that you have an authority that is not binding by you, you have a case that is before you, clearly, backed by this authority that is, bound, you are bound by, but you ignore this particular authority and go fishing for something else that is merely advisory to you. That is the whole point he sought to make. Now, we saw the exchanges, between members on the bench and the lead counsel for the petitioner on this same matter, because you recall that this whole thing about sections 26, 38, 72, this is not the first time it's come up. It's come up before as to which one is applicable, as to which one is not being applied. And so you find Mr. Chikata making this argument, in fact repeating the argument that you cannot seek to set aside this and then go fishing for something else. Again, we have seen the question of fair hearing, that there has not been fair hearing in this matter, occasioned by the fact that the witness of the first respondent did not avail herself after clearly demonstrating that she was going to avail herself to testify and be cross-examined. This is the argument of Mr. Chikata, and that because of this we have a situation where the the petitioner is incapacitated, the petitioner is unable to access justice, and so it is problematic. And that's why we hear the use of words like miscarriage of justice, that you do not think that the right was done by the petitioner because of this same reason of he not getting a fair hearing. But you may want to quickly balance that with the argument that we heard from the other side on this same question of fair hearing, that you had plenty of time in court. I mean, you heard Mr. Amenuva make that argument that the petitioner had plenty of time in court. He had a lot of favor in the eyes of the court, and Mr. Amenuva recounted the number of occasions on which the court, overlooked or indulged, that would be the better word to use it, indulged the petitioner on a number of applications, you see. So the petitioner cannot turn around to say there was no fair hearing. There was definitely fair hearing. So that's the argument we got from the first respondent in response to this. Again, the question of whether or not you have the sections, the three sections that we just talked about. You have 26, you have 38, and you have 72. If you look at the counter argument from the other two parties that we have in the petition, particularly we can look at the second respondent's lawyer, Mr. Akuzwan-Paul, reading the provision pointing out that the petitioner may have conveniently omitted a portion of the section in trying to make the case that the court had not relied on the appropriate authority. We had the portion about tendering in of evidence, that this is happened, the testifying and cross-examination is happening at the time of evidence, where evidence is being given. And the question is whether or not the petitioner was sidestepping or conveniently picking and choosing from the provisions which one makes his case for him. That's the argument we heard from Mr. Akuzwan-Paul, lead for President Akufo-Addo. But of course, there is the immediate, almost immediate response that the whole idea of this thing, the whole point on this application is to allow the petitioner to, bring in the evidence. He wants to reopen the case so he can bring in the evidence. But then again, question is from where? Because we've been here before. So from where? What is the nature of this evidence? Who will bring it in? And be cross-examined by who? We already have indication that the EC chairperson is the one they expect to do all of this through. What should happen in that case? Only the court can tell us.
And there was one point which also cut across the arguments of the two respondents in this particular matter. The point being that they believe that the petitioner had not met the conditions to be able to come for a review. Can you send us through that?
If you recall the submissions by Mr. Amenuva for the Electoral Commission, he talks about, he gave an authority that talks about the benchmark, the pillars upon which you can come for a review, whether the petitioner has met the benchmark, to even be able to appear before the court and ask for a review of the decision. And again, this is not the first time we are hearing about these benchmarks. What should the petitioner do, or what conditions should the petitioner have satisfied, to be able to enjoy this and overturn of the earlier ruling in his favor? Because it feels as if we have been here before. It feels as if we are talking about the same thing over and over again. And you would have situations where, well, we would have to wait and see. Remember, this is application number 3. We are seeing the review, for a review. So whether they were satisfied with the earlier applications, or they met the conditions in the earlier applications, the rulings for those earlier applications clearly tell us whether they met. In this particular case, we have a situation where you are expected to demonstrate the errors of law. You are expected to demonstrate that there was some evidence was not available to you at the time. You are expected to demonstrate that because of this, some substantial harm has been done to your case or your client. Again, we have to be careful in pronouncing whether or not they met these conditions, because that is the domain of the court.
Today, during the arguments, were times where there was the quotation of a Bible verse, a very interesting reaction from the bench in a reply to that particular Bible verse, Hosea. Can you send us through that particular time in the courtroom?
If you read arguments, particularly closing arguments, I used to love to read those. You just pick a closing argument and you read it. It's exciting reading some of those arguments. You see a demonstration of knowledge, not just of the law, but also of scripture, of literature, and all of that. You find lawyers oftentimes relying on scripture to make a point, because the authority of scripture is yet to be questioned by anybody, be it in court or even in the secular world. Yes, there may be questions of belief and all of that, but people tend to rely on this, as gospel truth or as the guide in drawing attention, bringing conscience and all of that. So you would often find lawyers reference scripture in aid of arguments they make. And you would often find the kind of language we saw in Mr. Chiketa's phrasing today used in a lot of these instances, where it says that we may be guided by the words of wisdom that were spoken many years ago by this prophet, by this preacher, by that person. And when that happens, again, we have a society where a lot of people are quick to conform when you mention the word of God or you bring up the word of God. And again, we have seen a lot of times Mr. Chiketa has tried to bring in the faith of Mrs. Jane Mensah into this matter. So it could be a question of strategy. Well, she believes in the Bible, the court believes in the Bible. Let us take them through some words of wisdom from the Bible to enrich the argument and to reconscientize the bench in a particular manner. Let us throw in a few scriptures to see how the bench will react to it, and so it's not strange that Mr. Chiketa had to fall on scripture to make the point. What was strange to me, however, was the reaction, more so from the bench. When I heard the laughter, I was looking amongst my colleagues. I thought one had forgotten himself, and strangely everyone was looking around. So then it occurred to me that no, it couldn't have been any of us. Then again, I looked down to see, from where we are able to see from below. Whether maybe one of the lawyers forgot that he was in the courtroom and decided to, entertain himself. Again, it wasn't a lawyer. This came straight from the bench, and that was surprising. I'm not sure. Tokono JC really intended to, let out that laughter. I'm not sure she intended to do that, because I mean, if it had come from any of us, that would have been something else. we probably would have been calling on our MD to look for a lawyer and come for us. So I don't know. I really don't think that, you know, that response was intended. I'm not sure. I'm not sure it was.
And the response by the first respondent, lawyer for the first respondent to that particular quotation was also very interesting.
Yeah, very interesting. He says that, well, there is God and there is the court. You cannot bring God from his throne high above into the courtroom down below to, you know, try to invoke the conscience of people. But you see, there's an interesting argument to that one too, that when you look at the role of the justices, and you look at the role of the justice system, there's something that they say about, you know, justices or judges administering justice in the name of God. And if you look at the symbolism of the wig they wear, and indeed all lawyers wear, and the whole of the apparel that you see the judge in, it means something, and it relates to divinity, or spirituality, you know, the place of God in the service of justice. You know, there's that connection. And so whether we cannot bring God from his throne high above into the courtroom down below and use him to invoke the conscience of people to take a decision in a particular direction, well, it's something else. But as I keep saying, it is not our place. It's squarely in the domain of the court to decide which argument is superior.
Today's argument did not go without the mention of the written closing submissions by the lawyers. We recall that the court gave somewhere last week Wednesday as a deadline for the closing submissions, written ones, to be filed in court. As of yesterday, our check showed that the petitioner had not filed their written submissions. This came up during the argument in the court. What were the concerns? Who raised these particular issues, and what were their concerns? The respondents from the second respondent and his lawyer raised concerns about the fact that, and he made this during the argument of fair trial, where he said that, look, there are too many opportunities and an open defiance of orders and directives of the court. As we speak now, can you confirm whether the petitioner, as of this moment, has filed? If he hasn't, what's it going to look like?
We cannot confirm that the petitioner has filed or has not filed. We know that also that really it's not compulsory. You must not file. It is in your interest to file your closing addresses. However, if you choose to waive that, if you choose to forego that, then that is your own pot of soup. What the closing addresses do is to aid the court, I have said before, help the court understand the case you have made in the duration of the hearing. So in this particular instance, we've had like 20 days of court, over 50.
Actually, we're in the 53rd day of the hearing.
No, since the case was filed. Yes, but the actual court days, the number of days that the court sat to hear, that's what I was. So like 53 since the petition was filed. And all this while, a lot of processes have gone on. Applications have been filed, applications, motions, they've been, you know, in and out, arguments made, and all of those things. In the interest of your case and of your client, the court is asking you a simple question, as you will say, a crackano.
The crackano say.
Thank you. That is the simple question the court is asking you to do with this closing address. So if you choose to not to serve the court with that, then the court can still take the pains to rely on the submissions that you have filed. Remember, you would have filed witness statements, you would have filed affidavits, you would have filed arguments, you would have a lot of things. So the court can still rely on these things to draw up its judgment. But the court cannot say that because you have not submitted your address, they are waiting for you. So in fact, with or without the addresses, the court can go ahead to set a date for judgment to be given, and it will deliver its judgment exactly the way it deems fit. What may come to you may even be sanctions that, where, like in the argument made by the consistently being made by the lead counsel for the second respondent, that you have a lawyer who seemed to be consistently flouting the orders of the court. And so in such cases, you may even have the court not taking kindly to your action at all, and may even pronouncing some sanctions on you. You get it? So, but I don't think that without the closing addresses being filed, the court is going to dilly-dally. It is definitely going to do what it deems fit.
As we speak now, we know the judges are in conference considering their ruling, and we also know that this particular set of judges who had this particular review is not the ordinary bench. There are 2 more people added to the ordinary bench to make 9 to consider the review. Can you tell us the 2 judges in this particular case?
Justice Henrietta Mensah Bonsu and Justice Amadou Tanko. I think this is the second time we are seeing them on the review, both of them.
Actually, Justice Tanko has been in all reviews. But this is the second time we are seeing
Justice Mensah Bonsu is coming. And so, I don't know whether maybe it will be left to the legal scholars, after all of this, to also, as part of the review, to see whether we shouldn't have even had entirely different justices hearing the different applications, the 3 different applications, or it's okay that we had the same justices running through all the 3 reviews. But of course, as I said, this is something that can only happen after, and minded also by the fact that the Chief Justice has the sole right or authority to empanel. We cannot question his decision. But with all the questions coming up about fair trial, just miscarriage of justice and all of that, just to give it a fresh twist, should we have had different set of judges hearing all the 3 different applications that we have seen so far, rather than have one run through all 3 and the other run through 2 of them. And because we know we have quite a number of new ones who were just appointed, new justices who were just appointed by President Akufo-Addo somewhere mid last year or ending last year. So I'm sure that we have enough hands to have done that. But of course, it's in the bosom of the Chief Justice.
A lot of people are looking forward to the interaction between Chachu Chikata and Justice Henrietta, Professor Henrietta Mensah Bonsu. You recall that in the last review in which she sat, the issue, this was with the review of interrogatories, there was the issue of crossing the bridge and the issue of why can't you do this during cross-examination. And Mr. Chachu Chikata, in all his arguments after that, had cited that particular interaction. Today, we had Justice Henrietta Mensah Bonsu as part of the justices to hear this review. What transpired between them with regards to this particular issue?
I can tell you that Justice Henrietta Mensah Bonsu is quite collected type. You won't see her jumping into interactions. She's lectured me before. I'm using that experience. So even as a student, when you are speaking, if you're asking her a question, she listens attentively and she answers you. If you disagree with her submission, this is classroom matter, not court matter. If you disagree with her submission in class, she listens to you attentively and points out, usually it's just one word, she will just use one word, point it out. Have you thought about this other alternative interpretation or analysis? And you take it from there. So you will not have, a Justice Mensah Bonsu or see a Justice Mensah Bonsu in that back and forth with a lawyer. She has not been a judge prior to this. She came straight to the Supreme Court. So we do not have the benefit of understanding her in this role from the lower court. That's why I'm using the classroom experience. You will not have or see her exchanging with a lawyer in that manner, like we saw the last time. You will not see her, preempting what your argument should be or should have been. You would not see her moving, crossing the bridge even before you get there. So that's the kind of Justice Mensah Bonsu I still see on the bench today, from a teacher to the bench. That's the kind I see, that she still maintains that kind of demeanor, composure, and she still comes across as the kind of justice or judge who would want to listen first, take it under advisement if need be, and then rule based on that.
You recall that Justice Mensah Bonsu asked one question and said, what does it mean when you said you have closed your case? Mr. Chachuchikata said, what I meant is what I said. And she said, okay, I'm satisfied with your answer. She didn't go further, and back and forth didn't transpire like we saw in other cases. And Basixus, the big question now is...
But you would also observe that a lot of the judges are, avoiding this confrontation we have seen in the number of days that the case has traveled. We look at Justice, remember the Chief Justice.
Which of them?
You were talking about the 72, 26, and all of the just at the tail end. Mafusau. You'd recall also how he handled it, that he did not push. He asked the question was answered, and then somehow he truncated it there. Even Justice Tokuno, from the one we have seen, in fact, she's the one we seem to see a lot in that engagement with Mr. Chikata, but that has also stopped. So I get the sense that the bench is trying to avoid this kind of direct back and forth with lawyers on their case.
As I said, the big question now is, when the court comes to deliver their ruling, what next?
A lot will depend on the pronouncement, actually. If the decision goes in Mr. Chikata's favor or Mr. Mohammed's favor, then of course they'll reopen, bring in the witness, seek leave to serve the subpoena and all of that. So that's another long haul for us. If it doesn't go in their favor, I'm not sure there are any outstanding issues that we can be preempting any more applications. So it will be back to the earlier directive to file applications, addresses, and then the court will take it from there. Or as we got the likely indication or unlikely indication on Friday, you would recall that there was a conversation from the bench about, we will come on Monday, we will hear the application, and we will set a date for judgment. There was this in open court. This was said by the Chief Justice himself in open court. So even if that indication is anything to go by, then we are seeing a situation where we are expecting judgment within the week. Because of course they would have to go back, put their thoughts together, take their time, write the judgment, and then deliver. So within the week, or some have even suggested early next week, because it's a lot of work for them to be able to do this today, tomorrow, and by Wednesday we are having a judgment. There'll be a lot of work. Then it will mean they won't sleep. So these are the scenarios we are looking at. If it doesn't go in Mr. Mohammed's favor, then it means the road is almost come to an end. If it goes in his favor, however, it means that we have to go around again and then take the witness, and that cross-examination will be an exciting one to watch. And if it happens, then it means that we have a number of days added to the hearing. Other than that, we are almost there.
During the last hearing, which was last week Thursday, there were rumors of a contempt case, which we are told that Mr. Dominic Ayene had been cited for contempt, even though we were unable to confirm it. Have you heard anything about it? Have you seen Dr. Ayene in court today? And what's happening with that?
Dr. Ayene is in court today. Remember, I asked about his whereabouts the last agenda. He wasn't the one who addressed the press, which was unusual. So I sought to find out from the legal team, the spokespersons, and we were told that he had gone for a funeral. So we see him in court today. We assume that all is well. The contempt matter hasn't come up yet. We know that it's still not over. Even if there's anything like that, it will still come up before the case is ended. What we are careful about now is to say there's actually a contempt case against him, because we have not officially cited any processes meant for service on the former Deputy Attorney General. And so we are careful how we put this, whether there's actually a case for him to answer pending or there is none. But the last time also I said that even if there is a case, there may be the mind to go through Parliament, considering that he is a sitting member of Parliament. And so there may just be that mind to go through Parliament in serving him with the charges to answer to. But yes, he's in court, and we still wait to see what happens after the ruling is given on this application with regards to the contempt case, if there's any.
You heard my colleague Sixtus Don Ulo, and we have been going through proceedings in court today, the review application which was moved by lawyers of the petitioner, and the responses by the respondents in this particular case. We are still awaiting the justices of the Supreme Court to come out of conference and deliver their ruling, after we also await for further directives as to how this case would go. But till then, let's take a recap of what transpired in court some few minutes ago.
mpono na bia atona akoma so na bia wa ma na bia refer say efie nwotwe ohun closing remarks na ehu hia pa sense ya de etime bua wonsem a wodi etudwa ene ade no
e man panimfo ntimi take final decision no
until say court shall say you say also you can't disobey the orders of the court. So court say you say no one ya ebekwatia. Oh, nam say no ono so ru achachu gidi say esan say mesemedi application abeto ono mo a mean to me cause court ntena so esan say atem
Okay, welcome back, and this is coverage of the 2020 presidential election petition that's going on at the Supreme Court of Ghana. As we're speaking now, we're waiting for the Hello?
Yes, can you hear me?
Yes, we can hear you now.
So I just shared section 72 on the screen. I hope you can see.
Shall we
see it? Is it clear?
Yes. Yes, we can see it's clear.
So this is the provision that the petitioner is essentially saying that the ruling of the court was without due regard to this provision, to the extent that the court focused on the definition of adverse witness in the Black's Law Dictionary without averting its mind to this provision. And section 72(1), as you can see, have certain parts have been underlined for emphasis. Basically, it begins by saying, subject to the discretion of the court in a civil action, a party or a person whose relationship to a party makes the interest of that person substantially the same as a party may be called by an adverse party and examined as if on cross-examination at any time during the presentation of evidence by the party calling the witness. So what I was saying was that first and foremost, this provision is discretionary. It gives the court that discretion, that ability to decide one way or the other when they are faced with
competing positions. And so they can either exercise their discretion in favor of the party making that application or not. What the petitioner is saying is that the court did not even have regard for this provision, in the sense that he is suggesting the court did not appreciate the fact that the Evidence Act dealt with adverse witnesses, but went ahead to deal or to cite the Black's Law Dictionary's definition of adverse witness. And what I was saying was that this provision does not necessarily define an adverse witness, but it tells us the circumstances under which a person or a party may be deemed to be an adverse witness. And that can only happen with the discretion of the court, or with the court exercising its discretion in your favor to be able to call that party, which could mean your adversary, the defendant or the plaintiff, as the case may be, or a person whose interest is substantially similar or the same of that party. So for instance, if you've sued a husband and now you want to call the wife of that man to testify on your behalf, it is natural to assume that that person, the wife's interest, would be adverse to yours, because it is more likely that she will give testimony that will favor her husband and not necessarily favor you, the one calling that person. But what the respondent was saying in response, which you Morris, I believe you talked about, was that the second respondent, or counsel for the second respondent, was placing emphasis on the last words in this provision, which says that all this that we've talked about, the fact that the court exercises its discretion and the fact that you may be given the option to call a party, it can only be done during the presentation of evidence by the one seeking to call that witness, who will be an adverse witness. Which means that it is when the petitioner was making his case that he could have exercised that option under this provision. That's basically what counsel for the respondent is saying, that it is when you are presenting evidence, when you are presenting your case, basically, that is when this provision will be applicable. But then we saw counsel for the petitioner basically suggest that that is exactly what they are seeking to do, because they are seeking to reopen their case for the purposes of presenting evidence. And so that's why I was saying that the only thing that we know for certain now is that all parties have closed their case, their respective cases, but the petitioner is now seeking to reopen his case to present evidence. So he's basically suggesting that he is not going contrary to this provision, and that the provision or the part which is saying during the presentation of evidence is applicable to them, assuming he's given the opportunity to reopen his case and that's adduce fresh evidence. And that's what I suggested earlier on, that the court itself, in giving its ruling on the 16th February, alluded to that if they are exercising their discretion to allow you to reopen your case, the same standards that have to be complied with when you are adducing fresh evidence is what has to be complied with at that point in time as well.
All right. So, per this review, what the petitioner is seeking fundamentally is to reopen his case. Now, there is an earlier ruling of the court which was even reviewed, and there was a final ruling that you cannot subpoena or compel a witness into the box. So now, even if this particular review, which the petitioners are seeking to reopen their case, is granted, there is another leg which says that you cannot force a witness into the box. I mean, so how do we, put the two together?
There are two different things altogether, and one has to do with the respondents closing their case and the petitioner praying the court not to case, because basically they said they were going to adduce evidence, so they should be compelled to adduce evidence. That's one aspect of what you're saying. The other aspect is the petitioner himself saying, now I want to reopen my case so that I subpoena the chairperson of the EC to testify as my witness, as an adverse witness. So that is the difference. There's a fundamental distinction between the court saying that the respondents are within their rights not to adduce evidence, and so their case, when they said their case is closed, their case is closed, and that is different from the petitioner saying, okay, now I also want to reopen my case so that I can cause a subpoena to be issued to compel the chairperson of the EC to testify. Two different things altogether.
Okay. All right. And Doc, we've seen about 3 review applications, and this is the 3rd one. Would it be fair to say that per what we've seen in the first, second, we shouldn't expect anything different in the 3rd one?
You know I can't answer that question. What I can do is to take us through the grounds of review of this particular application, and we've done with the first one, which is the Section 72.
Yes. Sure.
So if you permit me, I'll move on to the second and third grounds.
Let's move to the second and third, yes.
Okay, so because the petitioner argued the second and third grounds together.
Yes.
So ground 2 and 3. Ground 2 is as follows: that the ruling was in fundamental error in that it subjected statutory provisions in the Evidence Act to the provisions of subsidiary legislation. And ground 3 is that the court fundamentally erred in its interpretation of Order 38, Rule 3E5 of CI 47 as amended by CI 87. So these 2 grounds were taken together because they are similar. Okay. Basically trying to suggest that there was a substantive provision in an Act of Parliament, and the court rather relied on a subsidiary legislation to sort of override the express provisions of the Act of Parliament. So we need to look at what these provisions also say, what these provisions are, because that's what the petitioner is relying on. But before we even get to that point, the petitioner's argument is that the court made a fundamental error of law by subjecting subsidiary legislation to an Act of Parliament. And this is because, according to Article 11 of the Constitution, that sets out the laws of Ghana, it provides a hierarchy of some sort in terms of our laws, in terms of our laws. And it starts with the Constitution being at the apex. Then there are enactments made by or under the authority of Parliament, which will include an Act of Parliament. Then there are any orders, rules, and regulations made by any person or authority under a power conferred by this Constitution. The Constitution itself gives certain categories of persons and bodies power to make subsidiary legislation. It includes the Electoral Commission, which is given power to make regulations, for instance, for the conduct of elections, referenda, registration of voters, and all that. So they have that power. Then there's the existing law, which comprises of all the written and unwritten laws that were in force in Ghana prior to the coming into force of the 1992 Constitution, for so long as they are not inconsistent with the Constitution. And that's why we keep referencing NRCD 323, which is the evidence, originally the evidence decree passed by the National Redemption Council in 1975. But because the provision of the Constitution enables or allows the existing law, that is, laws prior to the coming into force of the Constitution, NRCD 323, which has been christened the Evidence Act, even though enacted in 1975, is still part of the laws of Ghana because they are not inconsistent, or it's not inconsistent with any provision of the Constitution. So you notice that there are numerous acts of Parliament enacted by the first Parliament even, which are still on our statute books, like the Criminal Offences Act of 1960 and all that. So that's just the points that I want to make. Then there's the common law, which includes the doctrines of equity, the common law itself, as well as Ghanaian customary law. So these are the laws of Ghana as espoused by Article 11. And the petitioner is saying that to the extent that the court in its ruling essentially suggested, and this is what the petitioner says the court was wrong on, that particular statement that the court made, that, and I quote, "We wish to state emphatically that Section 26 of the Evidence Act, which is on conclusive presumptions, is not applicable in this case in view of Order 38, Rule 3E5. And this is the basis for the argument of the petitioner, that to that extent, or to the extent that the court basically was projecting the orders in, or the provisions of subsidiary legislation above that of a substantive legislation, then the court had occasioned a miscarriage of justice. And this is the provision in contention here.
Section 20. Okay.
That's Section 20. I hope you can see it.
Sure, we can.
Yes.
Yes. So Section 20, and once again, I've underlined some parts for emphasis because that is the sticking point in the argument. The provision provides that except as otherwise provided by law, including a rule of equity, and we just established that by virtue of Article 11 of the Constitution, rules of equity and common law, as well as the Ghanaian customary law, are even part of the laws of Ghana. Which means that this provision is not all-encompassing. This provision is recognizing that it is possible that there will be exceptions that have been provided by law, including a rule of equity. It could include an act of parliament. It could include subsidiary legislation, and so on and so forth. So, except as otherwise provided by law, including a rule of equity, when a party has, by that party's own statement, act, or omission, intentionally and deliberately caused or permitted another person to believe a thing to be true and to act upon that belief, the truth of the thing shall be conclusively presumed against that party or the successors in interest of that party in proceedings between A, that party or the successors in interest of that party, and B, the relying person or successors in interest of that person. So this is the provision that the petitioner is basing his arguments on, that this is substantive legislation in an act of parliament, or substantive provisions in an act of parliament, but the court has subjected this basically to subsidiary legislation. This is the provision that talks about conclusive presumption, the idea that because the respondent, the first respondent in affidavits before the court, for instance, had intimated that the petitioner could cross-examine her to elicit those answers that he wanted by way of interrogatories, she had acted in a way that the petitioners had acted upon the truth of that matter to their detriment, because she had decided no longer to testify. And so this is what the petitioner is saying leads to a conclusive presumption, which should be what the court should uphold, that by making those statements and in the affidavits and filing the witness statements, it meant that she was going to testify, and that conclusive presumption should be made against her.
Right.
Is that clear?
But the respondents say that there's no point that the EC chair said she was going to testify.
Precisely. Sure. And in making that point and in making that argument, they rely on Order 38, Rule 3E of the High Court Civil Procedure Amendment Rules 2014 CI 87, 3E in particular, 3E5. And that's what the court also ruled or said in its ruling, that, and this is what it provides, and you permit me to read. Rule 3E5 provides as follows: that if a party who has served a witness statement does not call the witness to give evidence at the trial or puts the witness statement in as hearsay evidence, any other party may put the witness statement in as hearsay evidence. So the court in its ruling, which is being challenged by the petitioner by way of the review, suggested that Section 26 of the Evidence Act, which we just projected not too long ago, was not applicable in view of this provision. And we know that Section 26 said, except as provided by law, including a rule of equity. And we've just talked about what the laws of Ghana are. So what the respondents are saying, basically, is that the petitioner should not or has misconstrued the ruling of the court to the effect that the petitioner is suggesting that the court was subjecting the Evidence Act Section 26 to the rules in the High Court Civil Procedure rules, but that what the true position is that by virtue of the fact that the Evidence Act itself in Section 26 begins by saying, except as otherwise provided by law, including a rule of equity, that exception or those exceptions that have been created can be contained in subsidiary legislation, one of which is the High Court Civil Procedure rules, in particular Order 38 Rule 3E5. Is that clear?
Sure.
Yes. So that basically is the argument in relation to that. So on one breath, the petitioner is saying the court has subjected substantive legislation to subsidiary legislation, and that shouldn't be the case because we know that in the hierarchy of laws, acts of parliament take precedence over subsidiary legislation, so that if there is any conflict between a subsidiary legislation and an act of parliament, the provisions in the act of parliament will take precedence. That's the argument of the petitioner, that the court had erred in that regard. The argument of the respondents is to the contrary, that the court has not erred because the substantive legislation that the petitioner is referring to in itself provide that there can be exceptions which may be provided for by subsidiary legislation, because it says, except as otherwise provided by law, including a rule of equity, which means that the number or the category of laws are not exclusive. It includes a rule of equity, which means there could be other types of laws that may provide exceptions to this general rule on conclusive presumptions in relation to a party's previous statements.
All right, so apart from subjecting Act, the Evidence Act 1975 to Order 38 Rule 3E5, I mean, apart from that argument of subjecting the former to the latter, doesn't the Evidence Act 1975, doesn't it stand alone for an argument? Doesn't it make sense on its own? I mean, for an argument from the position of the petitioner.
So that's what the petitioner is saying. That so the petitioner's argument basically is that in the hierarchy of laws, the Evidence Act takes precedence over the High Court Civil Procedure rules. That is clear. Everybody understands this.
Okay.
So he's saying that to the extent that the court stated categorically, and I quote once again for emphasis, this is what the court said, quote, "We wish to state emphatically that Section 26 of the Evidence Act, which is on conclusive presumptions, is not applicable in this case in view of Order 38 Rule 3E5. And the petitioner is saying that this statement basically means that the Supreme Court is subjecting substantive law, that is an act of parliament, or that which is equivalent to an act of parliament, the Evidence Act. It is subjecting that through subsidiary legislation, which shouldn't be the case.
Right. And they have said that's not the case.
Yes, and the respondents are saying that, and even the court, I believe, speaking through one of the justices, essentially suggested that is not what
they
were saying.
Yeah, right.
And the respondents are saying that this cannot also be the case because the court, simply by saying that the Evidence Act is not applicable in view of Order 38, does not mean it is subjecting it to Order 38, but rather it is making that exception which Section 26 even recognizes, because Section 26 says or starts by saying, except as otherwise provided by law, including a rule of equity, that provision applies, which means that the law in itself recognizes that it is possible that that conclusive presumption which it is capturing, there may be exceptions to that situation, which may be provided for in law by virtue of subsidiary legislation or subsidiary laws, including even rules of equity, which in the grand scheme of things are even below CI 87, for instance.
Okay.
So that basically is the argument of the respondents in relation to that particular ground that the petitioner is seeking.
All right.
Which brings us to the next.
Before we move to the third ground, so let's go for a quick break, and when we return, we'll move to the third grounds and other areas. To stay with us.
The fourth ground, actually, the two grounds were argued together. So
okay.
2 and 3 have.
Okay. Stay with us. We'll be right back and look at the fourth ground. Stay with us.
Satisfied with the answer, sir. My lords, we continue finally to the last ground, that the ruling was in breach of Article 296. And my lord, very simply put, what we are saying is that that ruling is completely unreasonable in terms of what are often referred to as the Wednesday principles. And her ladyship, Justice Georgina Wood, as she then was, in the case of TDC and Musa against Atab Balfour, 2005-2006 Supreme Court Law Reports, page 121. Her ladyship, at page 131, expressed the specific terms of what such unreasonableness amounted to, and by saying that he, that is the plaintiff in this case, succeeded in showing that the case fell within the irrationality or unreasonable rule, in that the decision arrived at by the TDC defies logic and common sense or accepted moral standards, and that without meaning any disrespect to the TDC, no sensible or reasonable person called upon to apply his or her mind to the decision to be taken could have come to that decision. In short, the decision to throw him out of the house and force a residential plot on him is irrational and unreasonable. And we are saying respectfully that your lordships, in the exercise of your discretionary powers, unfortunately failed to advert your minds to relevant statutes, introduced irrelevant considerations which prejudiced a fair exercise of discretion as required by Article 296 of the Constitution. It is our submission that holding the first respondent, and particularly his chairperson, accountable for the exercise of powers conferred by the Constitution and statute, justify in the circumstances of this case that that chairperson be called upon to testify using the time-tested subpoena procedure that we seek to invoke in this case. My lords, there is no question that the process of review is among the ways in which corrections are made by your lordships. And as Aqua,
your time is up.
May I just finish in a minute because I am in the middle of a sentence? Is that allowed?
Okay.
As Aqua indicated in the Koglex case, heeding the promptings of conscience, as he put it, heeding fidelity to the judicial oath, he found it appropriate to reverse a decision of the ordinary bench. May each of your lordships decide in accordance with your conscience and your judicial oath. Ultimately, and even more profoundly, it is for the chairperson of the first respondent to come forward to testify as she indicated on oath she would do. I conclude with prophetic words that were spoken centuries ago. For they sow the wind, and they shall reap the whirlwind. These are the words of the prophet Hosea, to be found in Hosea chapter 8, verse 7. He that has an ear, let him hear.
Order in court, please. Order.
Yes. My lords, we are vehemently opposed to this application for review number 3. Lord, you have filed an affidavit in opposition as well as a statement of case, and we rely on it. Lords, under Article 33(1) of the Constitution, this court may review 133(1), my lords, 133(1) of the Constitution. This court may review any decision made or given by oath on such grounds and subject to such conditions as may be prescribed by the rules of court. Also, even the Constitution recognizes the role that is played by the Rules of Court Committee. And indeed, my lords, the Rules of Court Committee passed the Supreme Court Rules 1996 CI 16. And lords, the specific rule on review is Rule 54. Lord, this court is the final court of the land. We concede that the court is not infallible. But my Lord, your lordships may change your mind in an application for review only when certain conditionalities have been met. Lord, those conditionalities have been set out in Arta number 2 verses Arta number 2 to 2013-2014 1 Supreme Court of Ghana Law Reports 569 at pages 579 to 580. Lord, I will not read those conditionalities that are there. Lord, it's only when those conditionalities have been met that the review panel should seriously consider the merits of the application. Lord, our submission that the conditionalities set in Rule 54 of CI 16 and ATA have not been met by the applicant in this application. Lord, with the greatest respect, the grounds are basically an academic treatise of alleged erroneous pronouncements made by your lordship panel of 7. Indeed, if we want to give some credit to the grounds, my lords, they are best additional grounds that have been filed without leave of your court in terms of an appeal, but they do not form grounds for review for which my lords should grant this application. My lords, may I refer your lordships to the ruling that has generated this review at pages 11. With your kind permission, your lordships held accordingly in weighing the propriety of reopening proceedings to permit new or additional evidence to be led or tendered, the court will typically consider the following broad questions. 1. Will the evidence, if it had been presented during the trial, have had any influence on the result? 2. Could the evidence have been obtained before or during trial by the exercise of due diligence? Then your lordship concludes that in this application, the petitioner has not given us an inkling of the new or fresh evidence he wants to bring to the fore. Neither has he disclosed how that evidence would advance the cause of his petition. Lord, I believe that this is the crux, this is the ruling that the court made. And in the absence of any attack or any submissions regarding this application must fail. Lord, I say further, I submit further, that the grounds are very misconceived and have no bearing at all on your ratio that I have set out above. Even as submissions were made by the counsel for the applicant, and even as I'm speaking, still, my lords, the court is still not aware, it still doesn't have the inkling of the evidence that the applicant wants to lead for which the case should be reopened. And Lord, this leads me to the Wardyear case that was cited by counsel for the applicant. Because in that case, the evidence was known. The evidence was that there was an issue about Exhibit A. And by agreement of counsel, the court then said that let an expert come and testify as to the authenticity of the document. So in that case, the court allowed further evidence just because the evidence that the expert was being called was known. This is not the situation in this case. Lord, what has been done is that there has been arguments that border on the nature of an appeal. Indeed, if my lords look at paragraph 3 of the affidavit in support, with your kind permission, if I may read, he says that at the hearing of this application, I shall, through my counsel, seek leave of this honorable court to refer to all processes filed in this case up to the date of the hearing of this application, clearly indicating to your lordships that he is going to argue an appeal. And that is why your lordships...
It is an application based on previous processes.
Yes.
You see, so in motions,
yes,
what you try to do is that instead of seeking leave when you are on your feet, to refer to it, yes, you can capture it in the affidavit. Yes. So just ask for this one.
No, my lord, if my lord could hear me on the point I seek to make is that as a result of that, the submissions that were, for example, dealt with on the 18th have been brought in. For example, section 26 of the Evidence Act was dealt with. That's the point I seek to make by referring to this submission. My lords, this court had said time without number that the review jurisdiction is not an opportunity given to a party to come and argue the case again as if the review panel is sitting in judgment on appeal over the ordinary panel. And this is what my learned friend has sought to do. Lords, may I crave your indulgence to refer to the Standard Bank Offshore Trust Company Limited versus National Investment Bank. Lords, a civil motion number J7/50 through 2017. Lords, Dr. JSC, delivering the ruling of the court, admonished sore losers at page 17 of the judgment bars. From the ratio, with your kind permission, from the ratio of the decided cases of this court on review, it is immaterial if the applicant for a review considers the decision of the ordinary court to be wrong in law or has an emotional reaction to it, as in this case, the magnitude of the amounts involved or the shutting of the door to applicants because of the fraction of time in instituting a fresh action. These are not factors that a review bench normally takes into consideration. Because in that case too, the court went on and held that the rules of the court forms an integral part of the laws of Ghana, and consequently they must be given an equal amount of respect in order to produce the sanctity in court proceedings.
Mr. Menuvo,
yes,
are you referring to me as a sore loser? I argued that application for review before this court. I was studying where you were some few years ago, and I lost that application.
Well, my lords, the review panel forms that view of you. The review panel forms that view of you, my lord, and indeed of your client, my lords. My lords, incidentally, my learned friend was on the other side in that matter, and he got the review. Yes. Lords, the case of Mechanical Lloyd Limited versus Nati again is there on the point. Lords, arguments have been made in this court regarding fair trial. My lords, I ask just a couple of questions of the petitioner. petition, my lords, has been conducted in a piecemeal fashion, which is one of the things that CI 99 deprecates. First, orders of the court are disobeyed, file witness statement no. You yourself intimate that I'm going to call 5 witnesses. You call 2. And then you come back to the court, oh, my lord, I forgot one person, permit me. It is permitted. You call that person. Yes, my lord. Oh, my lord, this is the issue of fair trial. My lord, with the greatest respect, the issue of fair trial has been raised. And now I'm saying that he has been given fair trial in the way the case has been conducted, my lord. Well, then we go from there to having called the 3rd witness. What is your pleasure? Oh, my lord, I close my case of your own volition. Lord, it is my submission, therefore, that the petitioner was given every opportunity. He was fairly heard in these proceedings. And what has been filed, review number 3, is an abuse of the court processes, and the application ought to be dismissed in limine.
Mr. Menuva, you have not addressed us on the reference to Hosea, the gospel according to Hosea. Yeah.
My lords, I make
order, please.
My lords, my point I wish to make on that, if you permit me, is that God is a God of conscience, and God does not use court processes to elicit conscience. No. God is a cause of conscience, and therefore you do not bring God into the courtroom to now claim that because of God, application should be granted. That's my response.
Yes,
30 minutes.
My lords, we are opposed to this application, and my lords, we rely upon our affidavits in opposition filed on the 21st of February, together with our statement of case. My lords, our first submission is that this application woefully fails to satisfy the conditions for the grant of a review application. As in our view, it does not demonstrate any fundamental error committed by the court which has occasioned the petitioner a miscarriage of justice. And on that ground alone, this application ought to be dismissed summarily. My lords, now on ground A of petitioner's application, the petitioner refers to section 72 of the Evidence Act. Now, my lord, section 72 of the Evidence Act reads thus. So it's 72 sub 1. Subject to the discretion of the court, in a civil action, a party or person whose relationship to a party makes his interest substantially the same as a party may be called by any adverse party and examined as if
on cross-examination at any time during the presentation of evidence. At any time, my lords, during the presentation of evidence by the party calling the witness. My lord, it is very significant that in his statement of case, there is a deliberate omission of the controlling word evidence by the party of evidence. That is, and I see no reason to believe that this was inadvertent, because it is repeated twice, and on both occasions this critical word is left out of evidence. Now, what is the significance of adding of evidence, reading section 72(1), including of evidence? It means that a party can only exercise that right when he has not closed his case. That's what it means. And I want to repeat this. Section 72, which appears to ground the backbone of this application, relates to a situation where a party has not closed its case. Now, in this instant situation, the party had closed its case. So the court had no business referring to section 72(1), because it was irrelevant to the circumstances of the case. And my lords, it is my submission that knowing that they have closed their case, the petitioner disingenuously omitted of evidence. And with all due respect, this is highly improper. So, my lords, all the submissions around section 72 that the court was playing Courtroom of section 72 are totally unmeritorious and irrelevant. Now, my lords, we proceed to deal with grounds B and C. And my lords, counsel for petitioner has argued that Order 38 Rule 3E 5 cannot override section 26 of the Evidence Act, because in his view the Evidence Act is a substantive legislation, and Order 36 is subsidiary. Lords, 38, sorry, is subsidiary. My lords, it may well be a case that Order 38 Rule 3E 5 is subsidiary legislation. But the point here, the critical point here, is that the very principal act, this is the Evidence Act, section 26, by itself delimits the application of the main text by the words subject to the rule of law or equity. In my lords, there can be absolutely no doubt that Order 38 in 35 is part of the laws of Ghana. So it is because of the specific provisions of Section 26 that the court could then look at Order 38 Rule 3E5 and rely upon it in making its ruling. So, my lords, respectfully, I think it is misconceived to suggest that in doing so, the court has committed a fundamental error by allowing a subsidiary legislation to trump a substantive act of parliament. My lords, we would next address Rule 1C, which relates to Part 459, Section 58. Gandhi. My lords, in my respectful view, Section 58 of Act 459 is completely irrelevant to the matters before the court. Because the matters before this court, which is the subject matter of the review application, relate to the court's decision not to reopen the case. Well, that is the decision of the court. Now, Section 58 reads, in any proceedings and at any stage of the proceedings, a court, either on its own motion or on the application of any party, may summon any person to attend to give evidence or to produce any other document. My Lord, this provision presupposes that the party who is applying to summon another has not closed his case. You know, this is obvious common sense. It is very clear that this provision cannot relate to a situation where a party has closed his case. And my Lord, these are the ways in which provisions of the law have been persistently cited out of context. Perhaps to release those who do not know the law. So my Lord, it is a respectful submission that a reference to Section 58 of the Evidence Act, of the Courts Act, in this situation is totally misconceived. It should never have been made by counsel. My Lord, we wish also to make the point here, for the last time, that the chair of the first respondent has never made any undertaking that she would man the witness box, such that the petitioner could claim that he relied on it to his detriment. But all that the chair of the first respondent did was to repeat what the law is. That is all that you need. The law, and if your lordships go to Order 22, Order 22, All that the chair of the first respondent did was to repeat the position of the law, which is that if you fail to obtain interrogatories in relation to a matter, you may, during cross-examination, elicit the same information. That is all. It was never an undertaking, and it beggars belief that the petitioner and counsel are basing this statement of the law as an affidavit, an admission or a representation that they relied upon to their detriment. I therefore wish to submit that a reference to the position of the first respondent's chair on this matter can never constitute an estoppel, because she has the right to refuse not to enter the witness box. And the court has ruled definitively on this. This application for review of the decision to reopen cannot be the back door through which that earlier ruling can be considered. The court has ruled on it, and that ruling binds all of us, including counsel for the petitioner. Lords, the fair hearing argument, my lords. Yeah, 5 minutes more. Very well. My lord, I thought I had a lot more minutes. Unless your lordship thinks I've made out my case, so you have 5 out of the 30, you have 5 minutes more. Thank you. My lord, 9E relates to the allegation of breach of his right to fair hearing. My lord, the right to fair hearing is a right that all parties to a suit are entitled to. So, the court has ruled that the respondents have the right to elect not to adduce evidence. That is their right under the law. Therefore, to seek to reopen your case so that you can compel the first respondent through his chair to enter the box is a breach of
had answered those questions positively to allow the court discretion to be exercised in their favor. And it is against this ruling that the petitioner is seeking review from the Supreme Court, which we are waiting for the ruling as of now.
Okay.
All right, so Doc, we will have to from the Supreme Court. It does appear that they may be resuming anytime soon, but we are still here in studio as and when we get a signal that the Supreme Court has resumed. We'll take you to the Supreme Court to hear that ruling of a review of their own decision they made on the 16th of April, which says that the petitioners cannot reopen their case and subsequently subpoena the EC chair to mount the box to be cross-examined. And so we are still here, George. All right,
we have a signal. All right, 23 minutes to 1 is the time. We're going for a quick break, and as we wait for the justices to return, we'll go for a break. Stay with us.
Wow! That's a wise decision. Thanks, man. That's what we are Bema Kassan. You be the man. You there for what?
That's really a respectable decision.
When you be, of course, you know, it's time for testing. It's no big deal getting tested for HIV. The days of stigma are long gone.
There is life after HIV testing. Be bold. Get tested.
Choco cookies, made with the finest Ghanaian cocoa. Now introducing Piccadilly Butter Cookies, the new addition to the Piccadilly family. This advertisement has been vetted and approved by the FDA.
I am 7 years old. Beep, beep, beep.
I am 4 years old.
We are 12 years old.
It's been 1 year since I started my antiretroviral treatment.
You can live a long, productive life with antiretroviral treatment. With antiretroviral treatment, HIV-positive expectant mothers can have healthy HIV-negative babies. Go to the nearest health center, test and know your HIV status. If you are positive, ask about antiretroviral treatment and you will receive help. Antiretroviral treatment is your only option for a long and fulfilling life.
This advert is brought to you by the Ghana AIDS Commission and the National AIDS Control Program of the Ghana Health Service with funding from the Global Fund.
In Ghana, the law enjoins all drivers and passengers in a moving vehicle to wear a seatbelt. No excuse is good enough for not wearing a seatbelt. Seatbelts that are fitted in vehicles are adjustable, so please adjust it to suit you. Let it rest as close as possible to the body. As a driver, before you drive off, ensure everyone else, especially children in the vehicle, have fastened their seatbelts. The airbag is not an alternative to a seatbelt because in the event of a crash, only the fastened seatbelt will stop a passenger from being thrown far forward. So buckle up. Stop road crashes now. Stay alive.
This road safety education is brought to you by the National Road Safety Authority.
Lawful wedded wife to having to hold from this day forward.
I do.